I'm not really for sure what today's hearing is supposed to be about. So let me, before we get into any sort of large details with what's going on, I want to say two things. I want to remind Mr. Champagne especially, but also anybody watching, that it is against court rule to videotape or audio tape any portion of this proceeding. If you are to do so, the court may hold you in contempt. That is the same rule as in we were in person at the courthouse. It is the same rule that we employ here in the virtual platform. We are taking a record, and we will have that record available if the parties request it from the court reporter, and they seek the record and deal with the court reporter on procuring that record with regard to the fee. Okay, what do you believe you're here on today? And what do you think you're set for?
Yes, good morning, Judge Meachum. I'm here for my motion for declaratory relief and proper procedural protection, which was filed on...
I know that. I don't know what that is.
Oh, okay. So basically what I am seeking is a declaratory judgment from the court on several issues. I think the purpose of this declaratory judgment is to establish existing rights, status, and other legal relations where further relief is claimed or could be claimed as per the Texas Civil Practice and Remedies Code. So what I'm seeking to establish is certain rights and making certain that proper procedural protections are afforded to both parties, both Ms. Sau, who I want to state for the record again is a fit parent, as well as myself, who is also a fit parent, and making certain that those are applied. I don't think it will be necessary. Ms. Sau and I are pretty close to an agreement, but I want to make certain that both parties are protected.
And then why is this different than what you were here with regard to matters pending before Judge Cantu Hexel a few weeks ago?
So those were pretrial questions of law, and this is specifically asking the court to make declaratory statements regarding our rights and procedures. The other one was to see if the court would affirm certain Supreme Court case law, and this one is to get the court to make declaratory judgment regarding matters in the Texas Family Code and regarding case law that is related to preserving fundamental rights for both parties.
And it's related to the upcoming trial?
Yes, once again, I think Ms. Sau and I are pretty close, so hopefully we don't even have to go to trial. But, just want to make certain that everything is cleared and out of the way before any sort of trial happens.
Since this is a motion regarding the power of the court, I think that Mr. Champagne probably has a right to his public hearing, Ms. Sau, and I'm going to let him proceed on it for 10 minutes, Mr. Champagne. You have 10 minutes to lay out your argument to the court on a motion that the court doesn't quite understand, but I am going to allow you to lay out your motion for 10 minutes.
Okay, so, and real quick before we start, I had set this for 30 minutes for each side. Is there a particular reason why we're reducing it down to 10 minutes?
Because it's a non-evidentiary motion and the court has discretion to determine the length of time for a hearing. If I need more time after 10 minutes, I will let you know, but generally non-evidentiary motions that are fully briefed don't need very long to make their argument before the court. So 10 minutes. If I need more and if I have questions, we may go longer, but you're going to get 10 minutes, and then Ms. Sau will get 10 minutes if she wants it. And then we have two cases waiting behind you. So that's part of the reason. And then I have more hearings this afternoon. Our dockets are just overflowing these days. And so we can't give everybody the full amount of time they're asking for.
Okay, well, thank you for clearing. I appreciate it, Judge Meachum. Let me know when my 10 minutes is starting. I'm going to put a timer so I have that right here as well. So hold on 1 second so I can put my timer on, and that way I respect your time and Miss Sau's time as well. All right, let me know when I can begin.
You can begin now.
Okay, so the judge's affirmative duty is to ensure procedural safeguards sufficient to protect fundamental interests enumerated in this motion in strict scrutiny. As noted in the U.S. Constitution, Article 6, Ex parte Young, 209, 176, 177, and the Supreme Court in 1908. Anything in the Constitution.
I'm sorry. I want to interrupt and just make sure you understand. Ms. Racanelli is taking your record, but she can't get down everything if you're going to talk that quickly or read things. And so just be mindful. She won't interrupt you again, or I won't interrupt you again, but just understand that if you go too fast, it's going to make it hard for her, and she'll just put something like unable to read in her transcript. Okay, now you can go forward. I'll give you back those 30 seconds. Go ahead.
Appreciate it. State court judges have an affirmative duty to ensure procedural safeguards sufficient to protect fundamental interests enumerated in this motion at strict scrutiny. Anything in the Constitution or laws of any state to the contrary notwithstanding. See U.S. Constitution, Article 6, as noted in Ex parte Young, 209 U.S. 176, 177, Supreme Court 1908, as well as Zinnerman v. Birch in the Supreme Court 1990. Because petitioners had state authority to deprive the persons of liberty the Constitution imposed on them, the state's co-commitment duty to see that no deprivation occurs without adequate procedural protections. State judges, as well as federal, have the responsibility to respect and protect persons from violations of federal constitutional rights, as noted in Gross v. State of Illinois, 1963. The Texas Family Code in 151.003 specifically states limitation on state agency action. The state agency may not adopt rules or policies or take any other actions that violate the fundamental right and duty of a parent to direct the upbringing of a child. I am asserting that the following fundamental rights may not be infringed at all, as noted in Reno v. Flores, Supreme Court 1993, even incidentally to other state actions, Sherbert v. Werner, Supreme Court 1963, without the state showing on the record that the infringement is narrowly tailored to serve a compelling state interest. Once again, as noted, Texas Family Code 151.003, the limitation on state agency action. The First Amendment, right to free speech, inherent in the well-established right and duty of parents to educate their children in their own civic, religious, and moral values, formally and by example, through the intimacies of daily family life. The child has a co-commitment right to receive this education, and this right is protected in strict scrutiny. The First Amendment also guarantees free association and family association, and the right for each parent, including Ms. Sal and myself and the child, to live together as a family unit, sharing the intimacies of daily life, the experiences of which are the core concept of the family. The child has this co-commitment right, and each parent and child make up a constitutionally protected family unit. The 14th Amendment guarantees a liberty interest in the right to care, custody, and control and possession of a child, free from unwarranted government interference. There's also a privacy interest at stake here in a private family life shared between the individual parent and the child. This child also shares this right as well, and these privacy rights are protected at strict scrutiny. There's also a privacy right relating to companionship, care, custody, and control and possession, and this is also protected at strict scrutiny. I assert that there are many additional fundamental rights not listed herein, and I reserve the right to raise these procedural issues with this team. When the child's parents are married to each other and no prior court orders exist, each parent has equal rights to the child. I will note that in the Texas Family Code 153.003, there is to be no discrimination based on sex or marital status, and the court shall only consider the qualifications of the parent without regard to their marital status in terms of possession and access to the child. I assert that any classification of myself or Miss Sal as a type of fit parent whose rights can be infringed upon without full constitutional procedural protections based on either of us being a single or divorced parent, irrespective of the degree of conflict between us, is an invidious classification. Any alteration of these fundamental parental rights of companionship, care, custody, control, or possession of a minor child beyond protecting the equal rights of both parents is a constitutionally significant infringement on the fundamental rights of both parents and the child. When a classification is used to infringe on these fundamental rights, the classification must survive strict scrutiny review. This equal protection clause was intended as a restriction on the state legislative action inconsistent with elementary constitutional premises. Thus, we are treated as a presumptive invidious those classifications disadvantages of a suspect class. It is appropriate to enforce the mandate of equal protection by requiring the state to demonstrate that its classification has been precisely tailored. That's Plyler versus Doe, 1982. Many courts assert that child custody determinations in divorce are not constitutionally significant. However, the Supreme Court in Troxel versus Granville noted that the burden of litigating a domestic relations proceeding can itself be so disruptive of the parent-child relationship that the constitutional right of a custodial parent to make certain basic determinations of the child's welfare becomes implicated. As noted in the United States v. Jacobson in the Supreme Court in 1984, a seizure of property occurs when there is a meaningful interference with the individual's possessory interest in that property. Child custody is a possessory interest. And then see Delaware v. Prowse, the essential purpose of the prescriptions in the Fourth Amendment is to impose a standard of reasonableness on the exercise of discretion by government officials in order to safeguard the privacy and security of individuals. Regarding permissible state interest, for a state interest to be compelling, it must be a legitimate state interest, it must be specific, and the state must show that state action is necessary to protect this interest. The best interest of the child is not enough. It's not sufficient to meet these necessary requirements for invading fundamental rights, noted in Globe Newspaper Company versus the Superior Court. Strict scrutiny review has 5 distinct elements. There needs to be a burden of proof, and the state needs to look at which party carries the burden of proof. Regarding this, in cases of enhanced scrutiny, the state bears the burden of proof before any state judge can take any action, whether civil or criminal, regardless of who asks the court to take an action. There needs to be a compelling state interest. The general welfare of a child is a legitimate interest of the state. However, in the face of a fit parent asserting parental authority, a child's general welfare must be, by act of constitutional law, be considered protected, and therefore the state has insufficient authority to act. There needs to be a necessity for state action. And both parents are fit in this, and I'm trying to go through this quick. There needs to be a narrow tailoring or precisely drawn statutes regarding this, and there needs to be least restrictive means if they've passed all the other tests, and then they need to pass a least restrictive means test. I request that this court provide myself and Ms. Sal declaratory relief as follows. I request that the state declare that these substantive and equal protection rights are protected in strict scrutiny, or alternatively, to specify the precise degree of scrutiny that applies to each. I request that the state declare on the record that the state carries the burden of proof to demonstrate why it has a constitutional justification to infringe upon the fundamental rights of either Ms. Sal or myself and the child, or to classify either any one of us as anything other than a fit parent deserving of full constitutional protection, or to punish either of our child for the sins of either parent. I request that the state to declare on the record precisely what the state's specific legitimate interest is in interfering with these fundamental rights and classifying either Ms. Sal or myself as anything other than a fit parent deserving of full constitutional protections, and in punishing our child for the sins of either parent, and that the state declare on the record why it believes this interest is a compelling one, and that the state declare on the record the triggering event that caused the state to believe it is necessary to take this interest. I request that the state declare on the record the precise state statutes that authorize it to infringe on these due process and equal protection rights, and to show on the record that these statutes are precisely drawn to infringe only those rights necessary to achieve a legitimate stated state purpose. I request an opportunity to challenge this showing in a hearing and to argue these statutes fail to overcome the narrow tailoring test. I request that the state declare on the record that the relief requested the least restrictive means of achieving the state's asserted legitimate interests, and for the state to show where it has tried less restrictive means and those means have failed to achieve these interests. Should the state choose to grant any further or additional relief not specifically requested in writing, I assert the right to the same least restrictive means test in a hearing on that relief before that's ordered. I request the court declare specifically how all orders currently in effect meet the strict scrutiny procedural requirements, or immediately declare those orders void or void those orders. I request that the court immediately issue orders providing for the least restrictive means available to the parents to retain their equal parent rights, and for each parent to receive an equal in quality and quantity opportunity to exercise those parental rights directly. I request the state makes any presumption about the best interests of the child, as there can only be one primary parent, or that parents cannot both be full and equal parents, that the state declare those presumptions in writing as required under Texas Family Code 153.072, written finding required to limit parental rights and duties, and provide myself, the respondent, or Ms. Howe, should they declare her, an opportunity to argue against those presumptions in a hearing and be allowed to read case law into the record for appellate preservation. I request this motion be taken up as a summary judgment or summary relief and be ruled on before any further child custody proceedings that implicate substantive fundamental rights are heard. And I request the relief in the form of a final declaratory judgment order that may immediately be appealed under the state's declaratory judgment statutes. And I believe that completes it in 10 minutes or less.
All right, thank you. The court is ready to rule. If this is a motion for temporary relief or further temporary orders, the court is denying any relief requested by this motion. If this is a summary judgment or some other dilatory plea requesting relief, the court also denies it. This is not a final ruling. This case remains pending, and all issues related to matters of due process and constitutional protections related to parents and children and fundamental rights, they remain pending for final trial and the final trial judge. Good luck to the two of you in your continued negotiations regarding your child. You are excused and free to go. Thank you.
Real quick, Judge Meachum, do you want me to draft an order for you regarding your rulings on this to submit to the court?
If you want to draft a summary order, and understanding that I could work off that and I will make edits to it as I see are appropriate based on the ruling I just made, then you may do so. Or you can wait for me to rule and issue my own order. It's your call.
Okay. I'll wait for you to rule and issue your order then. I just wanted to make certain I understood your processes and procedures.
Okay, thank you. You're excused.
All right. Thank you. Have a nice day, Judge Meachum.